Good afternoon, and let me welcome all of you to our annual Tucker Lecture. It's really fabulous that you could all make it today, and I think you probably have a sense that you're in for a very special treat this afternoon. Now, the John Randolph Tucker Lectures were established by the Board of Trustees of the University in honor of Mr. Tucker's distinguished service both as the first dean of the law school and as a professor of law. The initial lectures were delivered in 1949 during the bicentennial of the university and the 100th anniversary of the Lexington Law School, which ultimately became our law school. The first Tucker lecturer was the former Solicitor General, presidential candidate, and ABA president John W. Davis, who in fact had graduated from the law school in 1895 when John Randolph Tucker was dean of the law school. Now, today's lecture, however, reaches much farther back in history to Rubenstein and the Magna Carta, whose 800th anniversary we're celebrating this year. You may remember that the Magna Carta was designed to settle the disputes between King John and his barons in 1215, and the goal was to limit the power of the king versus the barons. Now, this may seem like very ancient history, but if it were, most likely the ABA would not be dedicating an entire year to educational efforts about the Magna Carta. Chief Justice John Roberts said in a speech to the ABA House of Delegates that the Magna Carta expresses kernels of transcendent significance. And the ABA itself has called the Magna Carta a symbol of the rule of law, of the notion that nobody is above the law, including the king. And in fact, what you'll see is that there are few provisions of the Magna Carta reflected in our own Constitution today. Now, before I turn to introduce our keynote speaker, I want to recognize our alum, David Magna, class of 2002, who is a member and a former officer of the Baronial Order of the Magna Carta. Now, this means that David can trace his ancestry back to one of the 25 barons who compelled King John to agree to the Magna Carta. David currently serves as a trustee of the Magna Carta Trust and sits on the Magna Carta 800s Committee as a representative of the Baronial Order. Now, thanks to his persuasive powers, the Baronial Order, with support from the Magna Carta Trust and the 800s Committee, has established an annual scholarship at Washington and Lee. And this scholarship is designed to reward a student who's shown great aptitude and interest in the study of constitutional law and its historical evolution. Now, why choose Washington and Lee for this honor? Now, the reasons are twofold. First, both of our namesakes were in fact descendants of one or more of the barons. And second, the Baronial Order recognized that they were both involved in two, by different struggles, to establish and preserve those constitutional principles which the Magna Carta inspired in the United States. David, if you want to come up.
Thanks a lot. It's very nice to be back in Lexington, and she said just about everything I could possibly say about the scholarship, other than let you know who it is. Now, the scholarship is not going to actually be awarded until next month in Washington, D.C. at the Cosmos Club, but if you'll keep a secret, I would like to recognize the winner here in front of his or her peers and faculty, and present the winner with a book that was commissioned to commemorate the 800th anniversary. And the winner of this year's award will be Elaine McCafferty. Thank you very much, and enjoy the lecture.
Thank you very much. And now I'm turning to something that may sometimes be considered a duty, but today it is just a sheer pleasure and honor, namely the introduction of our keynote speaker. As I jokingly said this morning, I could actually spend the next 45 minutes on the introduction. He is such a distinguished person. But truth be told, you probably would much rather hear from him about the Magna Carta than from me. But I certainly want to give him an appropriate introduction. So we have with us today Professor A.E. Dick Howard, the White Burkett Miller Professor of Law and Public Affairs at the University of Virginia. And I think we can truly say that this is such a distinguished, true legal scholar and academic and teacher that superlatives barely measure up to all of his achievements. Professor Howard has devoted his professional life to analysis of the United States Supreme Court and constitutions, the federal constitution, but also state constitutions and constitutions in foreign countries. He is one of the most respected educators in the nation and has been listed among the greatest Virginians of the 20th century. 2 years ago, the University of Virginia awarded Professor Howard its Thomas Jefferson Award, the highest honor bestowed upon a faculty member at the University of Virginia. Professor Howard is a graduate of the University of Richmond, where he was valedictorian, though he told us earlier today that he almost went to Washington and Lee. Now, a few years later, we finally got him here. He also graduated from the University of Virginia's Law School, and he was a Rhodes Scholar at Oxford, where he earned a BA and an MA. After UVA Law School, he clerked for Justice Hugo Black when the court decided both Gideon versus Wainwright and Griven versus School Board of Prince Edward County. In 1964, he joined the faculty at the University of Virginia's Law School. But throughout his career, he not only taught, but he also continued to brief and argue cases in federal and state courts, including the United States Supreme Court. In the late 1960s, Virginia's governor at the time appointed Professor Howard as the state constitution's primary drafter. Today's state constitution derives its crisp, straightforward, and truly timeless language from Professor Howard's skill, but also from his vision of what a constitution should be. Subsequently, he was instrumental in the referendum campaign for ratification of the new constitution. And it's exciting that 72% of the voters in the state of Virginia agreed to adopt the Constitution. Subsequently, he counseled numerous governors, the Virginia General Assembly, and the U.S. Senate Judiciary Committee on constitutional drafting and related issues. Many constitution drafters from around the world have joined Professor Howard in Charlottesville to get his advice and guidance on the drafts of their constitutions. There has been no award he has not received in this country and abroad, including at least 5 honorary degrees. Needless to say, we are truly honored to have him with us today to give to this year's Tucker Lecture. Now, you may still wonder what might be the direct connection between King John, the Barons, and Professor Howard. Now, not surprisingly, he's written numerous books and articles throughout his career. And among his most influential works are 2 books on the Magna Carta, both frequently cited in this anniversary year. And in fact, if the biography on the web is correct, his first book ever was Magna Carta, Text and Commentary, and his other text on the Magna Carta is entitled The Road from Runnymede, Magna Carta and Constitutionalism in America. Professor Howard.
Thank you so much. That's such a gracious introduction. Such a gracious introduction, it makes me realize why I crossed the mountain to come over here today. I did have a scholarship to attend the undergraduate division at Washington and Lee, and I often wondered what might life have been like if I'd done that, but I had a father and a brother who'd gone to the University of Richmond, and I didn't want to face them if I didn't go to the University of Richmond. One reason it's nice to be in Lexington, I recall in the referendum campaign that you referred to, we got 72% of the votes statewide. We got 85% yes voted in Lexington. I mean, in politics, that's a landslide. Well, and thank you so much for the chance to be here to give the John Randolph Tucker lecture. He's one of the great respected luminaries of American constitutional history. a man who achieved so much in his own time, professor, dean, president of the American Bar Association, commentaries on the U.S. Constitution. I'm very honored and flattered to be here speaking under that lectureship. And the subject, as you know, is Magna Carta. 800 years since Runnymede. That's a long time ago. And, why would we care? I mean, what does it matter to us in the 21st century that this bargain was struck between a very reluctant King John and the barons at Runnymede? We wouldn't have it without King John. I have to start with him. I really want to kind of walk you through a few milestones, a few highlights of how we got from then to where we are now. But it pivots on King John. How many of you grew up reading Winnie the Pooh? I mean, if anybody didn't, you had a deprived childhood, locked in a closet on toasted water. But if you know Winnie the Pooh, you know A.A. Milne, who created Winnie the Pooh. You may, if you remember, have also read one of Milne's books called Now We Are Six. Some of you remember that little book. It has wonderful poems in it, one of which is called King John's Christmas. And it imagines King John lonely at Christmas. And it starts, if I remember the line, something like this. King John was not a good man. He had his many ways. And sometimes no one spoke to him for days and days and days. If you're a kid and this person is being outed, right? Being shunned. And tell you, no one could be that bad. Well, I grew up and I started reading about King John, and he was that bad. If not worse. It's no accident that no English king since that time has ever been called John. There will never be a John II because nobody wants to give a royal child that name. So we start with King John, Runnymede, June 1215, where John was one of the most luckless monarchs in English history. He managed to mess it up big time. He quarreled with the Pope over the selection of an Archbishop of Canterbury. He quarreled with the townspeople of London. He quarreled with, he tried to save the Normans' land in France. He lost all of that, the Battle of Bouvines in 1214. And of course he lost the loyalty of many, if not most, of his barons, because he was pressing them for money for all these adventures, for his foreign escapades and the like. So everything collapsed on him. Finally, it was really a state of civil war. So finally they met at Runnymede to agree on Magna Carta. He clearly agreed to the document with great reluctance. Indeed, it's pretty clear that he never meant to keep the promise. I mean, King John was not one of those people you would like to have on the other end of the contract. So we get Magna Carta. Most of the provisions we need not worry about here because much of it has to do with feudal relationships, when the barons would have to put up money to knight the king's oldest son or marry off his daughter or things like that. But it does have provisions which have an uncanny modern resonance. Two in particular, we refer to them by numbers for convenience, chapter 39 and chapter 40. Chapter 39 of Magna Carta says that no one shall be proceeded against except by judgment of peers or by, and this is the key language, law of the land. Law of the land came in time to be what we today call due process of law. Chapter 40, a companion chapter, said that justice should not be sold, denied, or delayed. And so they're the two provisions of all of the others that I think really seem to echo across the centuries. Well, that was 1215. Chances are we would never have heard of Magna Carta if King John had had his way. He actually persuaded the Pope to annul Magna Carta. Within about 2 months of Runnymede, Magna Carta was a dead letter in the eyes of the church. And then the situation quickly dissolved into what again was in effect civil war. Well, that would have been the end of it, but then King John died the next year. One chronicler said he died of a surfeit of peaches and new cider. I don't know if that's on any of the bar menus around Lexington, but my advice is don't order it. So he died the next year. Well, his successor, Henry III, was 9 years old. Now this is the Middle Ages. You've seen Game of Thrones. How long is a 9-year-old king going to live? the knives are being sharpened. So his chief counselor, the regent of William Marshall, hit upon a public relations gimmick. He said, all right, we will have Henry III reissue Magna Carta. And that will be a way of proclaiming to the people of England the new king's good faith, so that they can trust him. Well, that started the tradition over the years that followed, as each monarch came to the throne and reissuing Magna Carta. Now, as you might well imagine, given the common law tradition, Magna Carta evolved. Pieces were taken out of it, language was changed. In 1225, a major part called the Charter of the Forest became a separate charter. So it changed a lot over the 13th century, but it was there. I mean, Magna Carta survived. One of the curious footnotes of the whole story is that you assume it's called Magna Carta because it's a big deal, right? The Great Charter. What else? Well, the fact of the matter is, when they took the forest provisions out, they were important at the time. That was about a third of the original charter. Put those in a separate charter, you then had a larger one and a smaller one, so you simply call the big one Magna Carta, just to distinguish it from the little charter. Well, but history has taught us that Magna Carta came from greatness as well as size. In about the 14th century, there was an interesting statute passed by Parliament that specifically said that if any other law is in conflict with Magna Carta, it shall be null and void. Now, historians have conjured with what that actually means. It's doubtful that they had in mind Marbury versus Madison. I don't think that a court could pronounce an act of Parliament unconstitutional. I think it was more of a canon of construction. If a judge had a case involving competing statutes, you would prefer Magna Carta over the other one. But you're already at this early point beginning to think about Magna Carta as special. No ordinary statute is now on its road to being, in effect, a super statute. Okay, that's the Middle Ages. I'm not going to drag you through every century after that point. I think the next landmark to talk about is the 17th century. Because it's in the 17th century when the Stuarts come to the throne of England. James VI of Scotland becomes James I of England. And the Stuarts bring with them these notions about divine right of kings. Well, that's a notion that's on a collision course with the common assumptions of English constitutionalism at that time. And so when James I and the Stuart kings began to exercise prerogative power, especially again getting money or revenue out of the citizens, the parliamentary leaders responded. And the key person, the critical figure, was Sir Edward Coke. Coke was a judge, a parliamentarian, and he was the leading legal commentator of his generation, in particular commentaries on Magna Carta. So in Parliament, he basically resisted the Crown. He said that sovereign power is no parliamentary word. Magna Carta is such a fellow, he will have no sovereign. So he basically resurrected Magna Carta and put it on the table as a challenge to royal power. Well, if you know something about English 17th century history, it was a dreadful century for most people. Civil War, the execution of Charles I in 1649, lots of English people were dying in the name of religion and other causes. The struggles involved, among other things, a struggle over royal and parliamentary power. After the restoration of the Stuarts in 1660, the Stuarts, after all that trouble with the Stuarts, why they brought them back is really not clear to me, but they did. They said, okay, they're back on the throne. The struggles continued, leading finally, again, if you know this period, to the so-called Glorious Revolution. And I guess it was glorious if you were on the winning side, but not if you were on the other side. They finally, in that bloodless revolution, James II leaves the throne in 1688, flees to France. His opponents bring William and Mary to the throne of England. And the settlement at that time, the great constitutional settlement, produced the English Bill of Rights. So we have Magna Carta, the Petition of Rights, 1628, the English Bill of Rights. We now have the cornerstones of the modern British Constitution. In the English Bill of Rights, not the subject of this lecture, but if you peruse that document, you'll find some very familiar language provisions which carried over, in many cases, word for word into the U.S. Constitution or the American Bill of Rights. Okay, there's your English history lesson. I mean, where else are you going to get that much English history in so few minutes? You're now ready for the next cocktail party where you can throw out a gem or two to some English. They'll say, where does she get all that stuff? Why don't you just smile and say, I do a lot of reading. That's the English story. Now to the American side. This is where we begin to get closer to why we're here today. I mean, it's one thing for the English to celebrate, as they are this year. Why do Americans celebrate Magna Carta? It's not one of our documents on the face of it. Well, the story begins, I'm happy to say, in Virginia, with the Virginia Company Charter of 1606. The first permanent settlement, as you know, was at Jamestown in 1607. I was in Boston recently giving a lecture at Faneuil Hall, the James Otis lecture, and I had some problems persuading my New England audience that 1607 comes before 1620. Something about their math, which is really faulty, but I tried to be polite in Take a look sometime at the Virginia Charter of 1606. It's a remarkable document. Now it's a stock company. People bought shares in it. They thought they were going to get rich. All this gold and silver was going to be found in Virginia. But aside from all that, there's an interesting provision, striking provision, that says that immigrants to Virginia, those who come to the colony, will enjoy the privileges, franchises, and immunities that they would have enjoyed in the mother country. Now that's important because if you were a Spanish or Portuguese colonist, you couldn't point to language like that in your charter. Those colonies were ruled directly from the mother country. This, I think, was, what can I say? It was probably kind of an inducement, sort of public relations. It's like you go down to the travel agency and you're about to go to the Bahamas and you see this wonderful poster in the window showing the beaches of the Bahamas. Have you ever noticed it always has two people on the beach? You know, and then you go and it's lined with people. But you go, don't you? Because you want to enjoy it. Well, I think the Virginia Company Charter was saying to these people, you come to Virginia, you don't leave your rights behind. You bring your rights with you. Well, whatever it meant, the colonists believed it. They understood that to be part of their patrimony, including the rights of Magna Carta. Now, as you can imagine, English-speaking colonists in an English-speaking world, they reinforced over the 17th and 18th centuries, reinforced the introduction of English law. You could appeal certain cases back to England, to the Privy Council. The colonial assemblies were obliged to pass laws compatible with the laws of England. What was developing during those years was a sense of an external standard. Think about the idea of the American Constitution, the notion that all laws, federal and state, including state constitutions, must be compatible with the U.S. Constitution. I think that idea is being planted already in 17th century America by the notion that when you pass a law or decide a case, there's some external standard by which you judge it. Law books began to appear. If you look at the inventories of early colonial libraries, private and public, you find a lot of Cook. You find Cook's reports. You find Cook's commentaries on Magna Carta. You find a heavy infusion of the teachings of those events that I talked about in 17th century England. There were interesting episodes in Massachusetts, for example, where there were some dissenters who objected that the magistrates of the Massachusetts colony were not, in fact, giving people there the rights of Magna Carta, and the magistrates responded by a famous document called the Parallels of Massachusetts. They put in one column the laws of the provisions of Magna Carta, in the other column the provisions of Massachusetts law. I think there was a lot of special pleading going on. I think the document, frankly, was a bit disingenuous. But the important thing is that the magistrates who were ruling essentially according to the Word of God as they understood it, felt obliged to respond in legal terms to the challenge, to the complaint of these dissenters in Massachusetts. Well, that's the 17th century and the planning of ideas. As you move into the Revolutionary period, you reach another milestone. Because starting in the 1760s, as I'm sure all of you know, those you think back to your school days of American history, you begin to get, from the time of the Stamp Act and beyond, American discontent about British policy. As I say, I gave the James Otis lecture in Boston this year, and James Otis, you will know this probably from your constitutional law class, made a famous argument in Boston in 1761 against writs of assistance. And these were sort of open-ended general search warrants. And he objected to them the same ground you would object to a warrant today that didn't have probable cause. This is where the Fourth Amendment begins in James Otis's argument. He was objecting that these writs were being used to search the premises of colonial merchants and shippers. And he conceded that a special warrant would be okay, but not a general warrant. And he made the case as one of fundamental constitutional law in the way we would understand that proposition. He cited Coke in Dr. Bonham's case, 1610. That was an English case in which Coke said that acts of Parliament against right reason would be null and void. Now that begins to sound like constitutional supremacy. It begins to sound like Marbury versus Madison. The fact is, over the years, that doctrine never really took in England. Citations to Dr. Bonham's case began to die out in the 17th and 18th century. But Americans picked up on it. Otis cited Coke and Dr. Bonham's case to say there were limits on the power of Parliament. There are things that Parliament could not do because they would be, in the sense we talked about it, unconstitutional. And he would say that's where their power ends. Well, at this point, you get a clear divergence between British and American thinking about the Constitution. Because in England, at the end of the 18th century, you have Blackson's commentaries, and Blackstone laid it down in the 1760s. Parliament can do what it pleases. There are no constitutional limits on the power of Parliament. That was the British view. That's why they couldn't understand what these Americans were talking about. What do you mean, act of Parliament is unconstitutional? Blackstone doesn't say that. But Americans were rooted in the 17th century ideas of Coke, while the English had moved on into the 18th century ideas of Blackstone. So if you wanted a sense of why Americans and the British were talking past each other during the Revolutionary period, there you have it. Well, in the 1760s, at the end of what the Europeans called the 7 Years' War, what we call the French and Indian War, at the end of that war, Britain was victorious, but it had paid a heavy price, huge debts running from that war. And I'm sure, again, this is familiar history, that the British Parliament, the government were casting about for ways to pay off some of those war debts. And they said, look, we defended the American frontier. You were the beneficiaries of our policy. You ought to pay for both. And so that for the first time, Parliament imposed internal taxes in the colonies. They'd never done that before. There had been external taxes, but not internal. So that provoked an outpouring of resolutions and tracts and pamphlets and complaints against British policy. Stamp Act Congress met and said that the rights inherent in Magna Carta and the British Constitution were being violated by British Parliament. You got the Boston Tea Party, of course, probably the most famous act of civil disobedience at that time. Parliament imposed the Boston Closing Port Bill. They closed the port of Boston. They quartered troops on Boston citizens, so-called punitive or intolerable acts, as the colonists called them. So the other colonists rallied to the support of Massachusetts, and it resulted finally in the resolutions of the Continental Congress in 1774. Now, what's interesting about those resolutions is their eclectic quality, because there was quite a debate. Americans knew they wanted to complain. They said that something is going on here which is unconstitutional. We're not going to have it. But they were debating, how do you frame that argument? On what basis do you say we have these constitutional rights? Some people said natural law, or maybe the will of God. They were thinking in Lockean terms of the social compact. They said natural law gives us these rights to complain against Parliament. Other people said, no, we should cite the colonial charters like the Virginia Charter that I just mentioned. Others said, we should cite the British Constitution. We should cite Magna Carta. And what they finally did as so often happens at these meetings, they just merged them all together. So the final resolutions of the 1774 Congress articulate all of those grounds, the Colonial Charters, the British Constitution, including Magna Carta, and a heavy dose of natural law. And basically what they were saying was, look, you can put any label on it you like. Whatever you call it, it all adds up to the same thing. We have rights which you, the British, are not respecting. Now, that eclecticism will help those of you who are law students and have studied or are studying American constitutional law. If you find it messy and disorganized and not very neat, I mean, the French love everything. The French constitutional law is all very organized, so they would like to tell us. It all goes back to the code. But in America, it's just kind of a melange. It should give you comfort to know that that is the way we've been doing constitutional law from the beginning. It's always been kind of a mess. It's not Miller's fault. He didn't invent this. He was handed this package. Now, okay, so you get the Revolutionary period. Then you move into the period of adopting the early American state constitutions. And this is an interesting and often neglected period. You know, we seem to jump over that and move to Philadelphia, 1787. Well, in the American colonies, the colonies now declare independence. Again, it starts in Virginia, Williamsburg, May of 1776. The same body that instructed Virginia's delegates at Philadelphia to introduce the Resolution for Independence, the same day set to work on two documents, a Declaration of Rights and a frame of government. I think that's interesting because today you look at the Virginia Constitution, Article 1 is the Bill of Rights, and then you move on through the other articles. In the founding period, they thought of two distinct steps. First, a Declaration of Rights. Pure John Locke social compact. We have natural rights. We state those rights. Not only do you not give them over to government, you can't. They're inherent in the human condition. So you lay out those rights, and then you move on to a frame of government. And that's what the framers in Williamsburg did. George Mason was the principal drafter of, especially of the Declaration of Rights, which is right up there. If I had to compose a list of history's 10 most important constitutional documents, I put the Virginia Declaration of Rights in that list. As you read through the sections of that declaration, it's interesting how it starts with several sections that are pure Lockean social compact theory, and then it sort of segues into rights that are clearly drawn from and based on Magna Carta, the English Bill of Rights, and British constitutionalism. Now, there was one problem. Jefferson saw this. Jefferson was a great critic of the first Virginia Constitution. Partly, I suspect, because he wasn't there. And Jefferson couldn't imagine you could do anything like this without him. But he said, this is not a constitution. It was adopted by the same convention that's adopting ordinary law. You have to have a special body to adopt a constitution. Otherwise, it's just another law. And you can repeal it like any other law. Well, what we didn't accomplish in Virginia, I have to give credit to my friends in Massachusetts, they were the ones who finally perfected the modern American Constitutional Convention, which is to say electing delegates to a convention whose purpose is to write a constitution, and then putting the product of that convention to the people in referendum. So you put the Constitution on a popular foundation independently of the legislative process. It's one of America's great contributions, I would say, to the idea of a constitution. We move on then from state constitutions to the federal constitution in 1787, and here we're on new ground. We don't have a complete record of what was said at Philadelphia. We have Madison's notes, but a lot of what was said was never taken down. But as far as I know, no one ever mentioned Magna Carta. Really interesting. You'd think, gosh, if it's that important, if Americans were grounding their claims on Magna Carta in the Revolutionary period, how come it marches off stage and is in the wings somewhere? Well, I think the framers, the founding generation, understood they were about something fundamentally different from what happened at Runnymede. The contest in Runnymede that 17th century struggles with the Stuarts were all about the allocation of power, limiting royal power. What Americans were doing in the 1780s was creating a new government based on popular sovereignty. And so the Federalists argued that where Magna Carta was a grant from the king, the federal constitution was based on the will of the people. Moreover, they said, we are creating a government in which we're not only limiting executive power, we're also limiting government across the board. So the legislature would be limited by the Constitution as well as the executive, and that was really not something which the British had dealt with. Now, as you know, again, as students of American history, the process was nearly fatally flawed because the Federalists at Philadelphia rejected the idea of adding a Bill of Rights. So when the states went to ratification conventions, the anti-Federalists jumped on that issue. And they said, look, they've taken our rights away from us, no Bill of Rights. So James Madison and the other Federalists somewhat reluctantly agreed, okay, all right, just ratify the Constitution and we will add a Bill of Rights, which of course Madison and the others did at the first Congress. So what you have in this founding period is a very fascinating blend of innovation on the one hand, tradition on the other. The American innovations include, among others, federalism. I mean, try to explain federalism to one of your English friends. And they'll just don't get it. They don't think sovereignty can be divided in the fashion we've done in the American system. Another contribution, judicial review. British courts, English judges, UK judges still do not have the power to strike down an act of Parliament as unconstitutional. They do have, under the Human Rights Act of 1998, the power to declare an act of Parliament incompatible with the European Convention, but that only places on Parliament a political obligation to straighten up the statute and bring it into line with European law. There is no constitutional, legally, judicially enforceable obligation, so the British haven't gotten to that. But we basically, I think, long before John Marshall decided Marbury versus Madison, I think judicial review was already a part of the assumptions of American constitutionalism. So you have, I think, in that period, a bridge between innovation on the one hand, tradition on the other, in particular Magna Carta. So if you read the Bills of Rights, state and federal, that's where you find much of the legacy of Magna Carta itself. So given that historical story, what is it that we could say is the legacy of Magna Carta? I think several points. First, rule of law. The Dean mentioned the ABA. Lawyers love to talk about the rule of law. And they talk about it as if it's self-defining. I've worked with some foreign constitution makers over the years, especially after the collapse of communism. And I remember being in what was then Leningrad, now St. Petersburg, working with Russian drafters. This was back in the now forgotten era when we actually thought that Russia might become a liberal constitutional democracy. Well, it seems like a long time ago now, the age of Putin and the rest. But there was that brief moment where it looked like Russia would join the family of constitutional democracies. And I remember being at the table, I don't speak any Russian, so I was working through a translator, and it was a very good translator, a young woman who spoke fluent English, fluent Russian. But I discovered she was translating the English language phrase rule of law as socialist legality. Socialist legality. I said, I wasn't quite sure how to explain it. I said, no, that's not quite what we're talking about here. So rule of law is not such a self-evident proposition. But whatever it does mean, you can trace it right back to Magna Carta. Secondly, the articulation of fundamental rights. Now, I don't think in the 13th century they were thinking in terms of the way we in the modern era think about rights. I think that would be ahistorical. But Magna Carta not only has provisions dealing with the rights or the claims of the barons, but also it talks about the claims of free men generally. Now, one may debate who was a free man in the 13th century of England, but it clearly included more people than the barons. So there was a notion that somehow you'll have what we today would call rights trickling down to a more fundamental level. Thirdly, the whole idea of a written constitution. Every country in the world, except the United Kingdom, and Israel for peculiar historical reasons. Every other country has a written constitution. It is one of the, you adopt a constitution the way you do a flag or a national anthem. If you're a country, you have a constitution. And I think the idea of a written constitution owes a lot to the Anglo-American tradition that you write these things down. You put them into bargains between the king and the barons. You put it into charters for your colonies in Virginia and beyond, and you put it finally into constitutions. Fourthly, the idea of constitutional supremacy, and this one I think is really basic. Recall the law that I mentioned, 14th century statute that said you prefer Magna Carta over other statutes. Recall James Otis's argument that Magna Carta imposed constitutional limitations even on the Act of Parliament. You're on the road, even in the age of Magna Carta, even in the 17th century, you're headed towards what we recognize as the Supremacy Clause, right? That this Constitution and all laws enacted in pursuance thereof shall be the supreme law of the land. And as you know, John Marshall translated that as meaning judicial supremacy. But think about when you read Marbury versus Madison. Do you remember? Marshall doesn't start with the language of Article 6. He begins with what he calls the general principles of jurisprudence. He starts with the idea of a constitution. He develops that, and then finally, almost by way of an afterthought, he says, oh yes, by the way, there's Article 6. Look at that language. But he's basically saying, and I think this is what Supreme Court justices believed at the time, even if we had not had a written constitution, it was assumed there were certain things government could not legitimately do. There were limits. They couldn't take your property and give it to me summarily. That would be beyond the power of government. So I think that was a jurisprudential concept which owes a lot to Magna Carta. Finally, my fifth legacy of Magna Carta is the whole notion of organic, unfolding, evolving constitutional development. The notion that each generation inherits the Constitution, reads into it its own understanding of the language, and reinterprets it. It's not unlike the common law itself. It's really hard to understand American constitutionalism unless you have a feel of the common law and how it basically developed. Now, at this point, I'm tempted to use what in the ears of some people would be obscene language, pornographic language. Justice Scalia were in the room, he would certainly call it that. It's the phrase living constitution. I said it, didn't I? I said it. Now, you heard me say it, but I'll deny it if you say to Clarence Thomas or to Nino Scalia, I heard Professor Howard utter that phrase. But you know that debate. It's very familiar. Do you take the text in its literal meaning understood at the time of its adoption, or do you understand that phrases like due process, equal protection, cruel and unusual punishment are evolving concepts? Well, think about it. I mean, we could have a sequel lecture just on the history of due process. Think of the things that have been done in the name of due process of law over the last 2 centuries and beyond. The Lochner era of economic due process, the Warren Court and beyond, where we have personal autonomy rights of family and abortion and contraception and so forth. What more yeasty, organic provision has there been in the Constitution than the idea of due process, which, as I pointed out, was something which basically goes all the way back to law of the land in Magna Carta itself. Let me quote you what Justice Kennedy had to say. This was Lawrence versus Texas, the 2003 decision dealing with the Texas anti-sodomy law. And he said, those who drew and ratified the due process clause did not presume to know the components of liberty in its manifold possibilities. The times can blind us to certain truths, and later generations can see that laws once thought necessary and proper serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. Now, if there is a more clear statement of an evolving organic constitution than that, I have not found it. We will find out, in the next couple of months, whether that language as understood by that justice, gives us 5 votes on the Supreme Court to say that same-sex marriage is protected by the Due Process Clause. I'm not going to take cash bets today. I'll stake my reputation on what the Supreme Court does, but I never make money bets on it. But this one, I mean, it's how can you read language like that and not begin to think where that particular justice will come out of this same-sex marriage cases in short time. Well, that brings us finally to copies of Magna Carta. Well, this is an epilogue, this little footnote, as it were. There are a lot of copies of Magna Carta floating around. They count something like 17 copies from the 4 extant copies of the 1215 Charter to the copies of the 1297 Charter when it went on the statute books of England. Of all those 17 copies, one is over in Australia. All the rest are in England except for one that's here in America. If you go to the National Archives, over in the corner there's a little, looks like a sort of reliquary, sort of Gothic shrine. You think you're going to find Veronica's veil or a piece of the True Cross or something like that, but it's actually Magna Carta. I was on an airplane flying to London a few years back, and sitting next to me was a Texas lawyer who was Ross Perot's personal lawyer. We got to talking. His income, by the way, somewhat exceeded mine. I soon figured that out. Professor versus Texas lawyer. We talked about Magna Carta. It turned out that he told me the following story, that Ross Perot, who I guess owned pretty much everything else, heard that there was a copy of Magna Carta that might be for sale in England. A private family owned it. So he sent this lawyer over to bargain for the purchase of it. And it was true enough, they did have a copy of the 1297 Charter. So Ross Perot finally agreed to pay $1.5 million. This was back in the 1980s. It's a fair amount of change even for a historical document. So this lawyer buys this copy of Magna Carta for Ross Perot. And I said, but you know, surely England has laws about exporting their patrimony. How do you get a copy of Magna Carta out of England? He said, well, the first thing I did was roll it up and put it in a mailing tube. This is a priceless document. You put it in a mailing tube. He says, yes, then I went to Heathrow Airport and I'm going through customs. And the customs agent says, what have you got in the tube? And the chap says, I have a copy of Magna Carta. And the customs agent says, right, mate, go right on through. He thinks he's got a facsimile of Magna Carta, right? You go in some store in the Strand and buy. So it gets on the air. And I said, you get it on the airplane. Okay, but what do you do then? He said, then I'll put it in the overhead bin. And I said, but that's where people with their ski boots and their backpacks, and you put this up and do it. Well, somehow it survived. I mean, only in Texas can people be this cavalier. So it gets back to this country safely. It was then on display for some years in the National Archives. Well, then Ross Perot decided he didn't need a copy of Magna Carta anymore, so he decided he would put it up for auction at Sotheby's in New York. And it went on auction. David Rubenstein, the very wealthy philanthropist who's aided a lot of historic properties, heard about it, bid over the phone for this copy of Magna Carta, and paid $21.5 million for it. Not a bad profit on Ross Perot's part, from $1.5 to $21.5 million. Well, the National Archives then asked me if I'd come up and give a lecture. Would I talk about Magna Carta? They were going to put this copy of Magna Carta on display. I said, sure, I can do that. Well, each Thursday, the Washington Post has a little box that talks about 3 or 4 interesting things that will happen the next week in Washington, and one was my lecture. And it said something like, on Tuesday, March the 30th at 7:30 p.m., Professor A.E. Dick Howard of the University of Virginia will talk about his book, The Road from Runnymede, and his purchase of a copy of Magna Carta for $21.5 million. So I said, oh, right. I went home that night, talked to my wife, Mary. I said, Mary, you're going to start getting some very interesting phone calls from people who are going to invite us to some very fancy parties. I said, don't ask any questions. Just say yes. Well, that was my moment of glory. Don't I wish people would think if that professor's got $21.5 million for Magna Carta, there's a lot more money where that came from. So that's something, if you go to Washington, you see that copy. So there you have the account not only of Magna Carta in England, but Magna Carta in America. So that, I hope, is a way of addressing the question I started with, because we don't live in feudal times. You know, we don't have a monarch. I realize you and I have friends who think that the incumbent president or some of his predecessors are every bit as bad as King John. Okay, that's American politics. But we don't at least have a king. We're not concerned about the pretensions of the Stuart monarchs. But I think Magna Carta lives and breathes and is vital today as a reminder that we, in our time, as in the 13th and 17th and 18th centuries, we are still grappling with the fundamental questions of how do you finally achieve under a Constitution the promises of order and liberty. Thank you very much. If you enjoyed that lecture, you are certainly welcome to write my dean and tell him so. I understand we have a few minutes for questions. I'm delighted to take questions or comments or anything you want to offer at that point. So this is your chance to nail that final con law exam with some little turn of phrase that will impress your professor. Yes?
I understand King John is the son of Eleanor of Aquitaine, who surely was one of the most politically astute women in history. How did he not learn anything from her?
Well, isn't history full of people where you have learned and able and astute parents whose children go off the rails? But, I mean, think about who's King John. I mean, there are those who probably want to rehabilitate King John. There are people now who say Richard III wasn't as bad as Shakespeare painted him to be, and so maybe he'll come back maybe he didn't kill the two princes in the tower and all that stuff. But imagine you're King John, and your older brother is named Richard the Lionheart. There's strike number one, right? Richard the Lionheart. And then you earn the title John Softsword. Strike number two, right? Begin to get the picture. I think this resentment could begin to bubble up. Some historians say that the real complaint ought not to be against King John. It was not that he personally was so bad. The complaint ought to be against the Plantagenet kings. That from Henry II's time onward, they were building a system in which they, for example, Henry II centralized the courts. Well, sounds like good government to us. What he was really doing was bringing revenue out of baronial courts into his courts. More money for the king every time it's not just court fees. In those days, you were buying and selling justice. You were buying the favor of the crown to decide a case in your favor, or maybe hold a case off indefinitely, whatever it might be. Revenue. This was a Plantagenet invention. Now, King John did more of it. He also was fumbled public policy. I mean, he was just maladroit in running the government. But the system that was in place was a Plantagenet system. Now, I suspect that's a larger concern than just one king. Now, I'm not trying to rehabilitate King John, but it suggests the picture may be a little more complicated than A.A. Milne thought in that poem that I quoted earlier. Nice question. Thank you so much. Yes?
I was wondering if we could get your thoughts on the growing number of states that are passing legislation to request another constitutional convention.
Yes.
And other than the possible money you might make from the demand of your services, which would be inevitable, what do you think about that progression, the idea, and if enough states pass such legislation?
Well, I appreciate the fact that you suggested I might have a personal stake. If you're going to have a convention, hire me to run. Okay, then I think it's a great idea. I'm Thomas Jefferson. I want to be there. I have taught and worked with constitutional law long enough that I suspect if you cared to trace my record, you'd find it was not nicely consistent. I teach at a university founded by Thomas Jefferson, and he famously wrote a letter to Samuel Kercheval in 1819, And he laid out the argument that each generation should rewrite the Constitution. Now, he was talking specifically about the Virginia Constitution, but you could apply it at the federal level as well. He took actuarial tables of that day and age, European tables, that said of all the people then 21 years of age and older, in 19 years, half would be dead. So he said that's a generation. Well, today people live longer and all the rest, so maybe call it 30 years. But there is a generational idea. If you believe Jefferson, at some point you should revisit, rethink the Constitution. Now, I think of myself as everybody wants to be a Jeffersonian, right? We all wrap ourselves in the name of Thomas Jefferson. And I certainly, when I was going around the state making the pitch for the present Virginia Constitution, I was running the referendum campaign, I was quoting Thomas Jefferson. The last Constitution had been written in 1902. That was 60 years earlier. And I said, by anybody's calculation, that's too long. It's time we updated the Constitution. Of course, the old Constitution was racist and populist, a lot of bad things anyway. But I invoked the Jeffersonian principle. Well, if I'm true to my colors, it's now time again. Well, maybe I'm not as consistent. Maybe I'm not as Jeffersonian as I used to be, because I think about, whether it's a state or a federal convention, I think about how simply dreadful it would be. I mean, think of the people who show up. It's not that we don't have 55 people just as smart as the ones who were at Philadelphia. We probably do. But they're not the ones who'd be at the convention. It'd be every crazy in sight, every special interest group. You pick the special interest. Abortion, anti-abortion, gun control, pro-gun, on and on. You pick the issue. The special interest groups would insist that they be there, be represented, and that their claim to be put in the Constitution. And if it wasn't, they don't care about the rest of it. The whole thing would collapse, I think, and it would be, I mean, especially the atmosphere of modern American politics. Congress can't get resolutions through to decide where the bathrooms ought to be. So, I mean, if Congress is at gridlock, just imagine a convention. So it's probably one of those cases where a beautiful theory, the idea of constitutional revision, is mugged by a gang of facts, the gang of reality. I guess that's where I come out. Is that, that's the best answer I can give. Unless, proviso, footnote, unless they hire me. That's question in the back, yes.
Do you think there's space in this debate for the intent of the barons who created the Magna Carta? Because we have a lot of debate about the intent of the framers of the Constitution. But if you're operating under the assumption that it took their inspiration from the Magna Carta, why don't we really have more people speaking on the mindset of the barons who wrote it? That's
an interesting question about the mindset of the barons. I have to assume that the barons were a pretty mean and ugly crowd. I don't think I'd want them at my dinner table. They were probably unlettered, uncouth. They probably smelled bad for all you know. And they were very self. They were out to protect their own interests. They were not operating in the common good. Unlike, I would argue, the framers of Philadelphia. I rejected the Beard thesis that the framers were just a bunch of self-interested people looking out for their economic interests. Maybe they were. But I think they understood a larger purpose. They understood the common good. I don't think the barons were thinking like that. However, the barons, it's not clear who actually wrote Magna Carta. I mean, we've got the document. We know that scribes were knocking out copies of it to be sent out to the various cathedrals in England. But we don't know who it was that actually provided the content of it. Probably a mix of people. One guess is that Stephen Langton, the Archbishop of Canterbury, was one of the architects of the arrangement. And so there's some sort of canon law in there, church ideas. The Magna Carta, in its very first provision that we now call Chapter 1, says the English church shall be free. So the church is very much protected by the document. But it may well be that these provisions that I mentioned earlier that suggest that the protections and claims of Magna Carta reach beyond the barons just to the free men of England, to other people, that may have been something that Stephen Langton's idea. I doubt that the barons themselves had much interest in doing that. That would limit their authority in their baronial courts. So I think there may have been a mixture of self-interest and some sense of larger purpose, unrealized at the time to be sure, but strong enough that that's one reason I think that the provisions and ideas of Magna Carta survived the century so well. Thank you. Another nice question. Lovely. Thank you. Yes?
That's fascinating talk. Thank you so much. I had a question about the populist support for a constitution that you talked about earlier, and how when you look at the Magna Carta, it was the king and the barons directly negotiating over this document.
Right.
And sort of over the centuries, we've now have these intermediaries between the people and the government, and also between the people and their document. I mean, there are many Americans who never read the Constitution, don't know what's in it, or the Bill of Rights. How do you think that shapes the way we view the purpose of our Constitution and the input that our citizens, the grassroots citizens, have?
You know, that's an interesting. This is a question about the sort of, as I understand it, the relationship, or the mediating of the relationship between the Constitution at one level, Magna Carta or our Constitution, and ordinary people who lived under it. You have to think of the Middle Ages as a system, as kind of a corporate society, in the sense that there were lots of, like the city of London, or the various towns and boroughs, would typically buy certain privileges from, that was another source of royal revenue, was to sell privileges to these corporate bodies. So even in the 13th century, you had trade and commerce and the like, and you had groups that in effect were organizing for that purpose. The barons organized in a sense. They had, for example, to enforce Magna Carta, the last provision of Magna Carta, chapter 63, says that they shall appoint 25 barons who in effect ensure that the king keeps his promise. So they were thinking in a collective sense. It's hard to imagine in the Middle Age the sort of atomistic theory that came about in the 17th century and beyond of individual rights. I mean, that really is an idea that begins to take shape, I think, as natural law of the Middle Ages, which is essentially sort of organic, if you like, begins to give way to a modern sense of natural rights. I mean, some fairly modern, what we call human rights today, what I think were natural rights, that begins to appear with social compact theories like Thomas Hobbes, John Locke, Jean-Jacques Rousseau, and people like that. That's very modern. And it comes into being about the time where the predicates are being laid for modern constitutions. So the age of constitution writing, in our sense, really begins in the 18th century, building on these 17th and 18th century ideas about the relationship between the individuals and the state. And I don't think people in the Middle Ages thought that way. It's interesting, an analog, I think, to her question. One thing that struck me in working with post-communist countries after the Berlin Wall came down, after the collapse of communism in 1989, was how effective the communist regimes had been in Eastern Europe, for example, in destroying all the vestiges of civil society. What they wanted was direct relationship between the party and the individual people. And there'd be no competition for that. The church, labor unions, private organizations, on and on, they were all either destroyed entirely or made ciphers and functions of the state itself. And I think in modern society, we really depend on these intermediate, on what we call civil society, that effective constitutional democracy functions best when you do have mediating bodies that actually give people a chance to organize, to petition, to use their rights of association to represent themselves before government bodies. So I think this is not reconstituting the Middle Ages, but it's recognizing that a system is not simply going to be you and I as individuals and the government up there somewhere. We have to work with the government through something intermediate. So in a curious, functional way, you had some precedent for that, I think, at the time of Magna Carta itself. Does that kind of go where you hope the answer would go? Thank you. Yes, ma'am.
Yes, you mentioned how one of the purposes of the Magna Carta was to limit executive power, and that seems like that bled over into the Constitution, to the American Constitution, as limiting executive power by dividing sovereignty. With this new fourth branch, as some have been calling it, the administrative state, how do you think that plays into what the purpose of the Magna Carta was, and perhaps the original purpose of the Constitution, to limit executive power?
That's such a good question about, in effect, the fourth branch of government, the rise of the administrative state. I think that's something, again, that's very modern. that at the time of Magna Carta, first place, you didn't have a sense of separation of powers, of branches of government. I mean, the king basically was called the shots in every respect. Think about courts, for example. The word court could suggest a royal court where the king sits on a throne, wears his crown. It could suggest a place where judges sit and decide cases. At the time of Magna Carta, it was one and the same. And one of the interesting things that Magna Carta does is address the complaint that people had, was that wherever the king went, the court went, and that's where cases went. There are records of people following the king around for 5 years before they could grab him long enough to get him to decide a case. And so one of the provisions of Magna Carta says that justice shall be given in a place certain. That turned out to be Westminster, ultimately, where the royal courts sit. So at that time, you had nothing like the modern notion of branches of government. Again, in the early modern period, 17th, 18th century, theorists like Montesquieu would begin to think about the idea of separation of powers. What's interesting, as I understand European theorists, they were talking about separation of function. That it's convenient to have some people making laws, other people executing laws, other people interpreting laws, but they didn't mean what we call separation of powers. It did not imply checks and balances. And that's a Madisonian contribution, that the idea of separation of powers implies directly checks of various branches, that you have the bill-making process, the veto, overriding the veto. That's all examples of checks and balances. This is very modern. Even more modern is your question about the administrative state. I don't know exactly where it began. I would argue that Bismarck's Germany is a good place to look. That it began in Germany in the late 19th century. In the 20th century, you get Wilson's administration, the alphabet agencies like the Federal Communications Commission. In the Great Depression, the Roosevelt era, you get, of course, the explosion of the administrative state. And so much of modern constitutional law, both in this country and in other countries, has to do with how do you deal in constitutional terms with something which isn't quite like one of the three other branches. It's kind of a mix of all those branches. And as you know, with some of the justices on the modern Supreme Court, John Roberts, for example, are very concerned about the untrammeled reach of administrative agencies' powers, and they would like to trim that back. I think they would like to take things back to a simpler age before we had those administrative agencies. That's where I think their heart of heart lies. But that is really a challenge. It doesn't fit traditional models very, very well. It's why I don't teach administrative law. I do constitutional law. It's simple. Let somebody else do administrative law. That's complicated. Thank you for that question. Russ.
Yeah, I have it may sound terminological or just semantic, but it dawned on me in hearing the lecture that in fact Magna Carta doesn't constitute anything, least of all the state, in the same way that the project in Philadelphia was about constituting a polity, or really even constituting a state. And I'm sensitive to that. You'll indulge me for a second, but I'm sensitive to that because, of course, the Germans adopted the terminology of a basic law. They didn't use the term because Germany existed across multiple iterations of constitutions. You don't need to constitute the state or the polity. You just have to recharter the framework for how the state will behave.
You know, I think
on those terms, do you think it's fair to be talking about constitutions and Magna Carta at the same?
You know, that's a wonderful question, and it really is almost an etymological question about what do you mean by the verb to constitute and the noun constitution, and also the noun constitutors. Who are the people? Who are those that constitute a constitution? And you don't think about it. You just sort of say it's there. We, as I say, every country but 2 or 3 have constitutions. And they bracket systems where, on the one hand, the United States. The several states, they might not have been able to make it alone, but theoretically they could have stayed separate. Rhode Island tried to stay out, dragged reluctantly in. Some ratifying conventions, North Carolina said no, and then later said yes. Some of the states were very close. New York and Virginia almost voted no. But they had a sort of a jurisprudential choice. And so the Constitution, and you rightly say, really does constitute the American Republic, and the people are proclaimed in the first 3 words of the preamble to be the ones who do the constituting. And that's such a powerful American model, you tend to forget that's not the way so many other countries work. That Germany is a good example. The casual observer might suppose, well, with the Basic Law of 1949, that's where it begins. And that would overlook centuries of German constitutional tradition. I think much of what you find, and you know more about this than I, but I think the Basic Law of 1949 reaches back and incorporates some of the ideas of the Frankfurt Constitution of 1848. We forget, we think this all Nazism and World War II. There's a powerful constitutional tradition. And Germany, I mean, my goodness, it goes a long way back. And it would above all be true of Great Britain, that none of the documents that I mentioned, Magna Carta, Petition of Right, English Bill of Rights, Human Rights Act, none of those documents constitute something which has been understood to be in existence all the time. And this is another reason why the difference is so striking between British and American ways of thinking today about their Constitution. Just as a footnote to that, follow the press accounts in the next few weeks of the general election in the United Kingdom. It comes up in May, just a few weeks off. They used to have in the United Kingdom a simple duality of Labour and Conservatives, and they would just change hands depending on the election. 6 parties will be competing. Some are minor parties, but the chances of no one having a majority is very good. They will probably have an awkward coalition of some kind, including some people who want to get out of Europe. And the reason I mention it here is that with the referendum last September, in which the Scots voted on whether they wanted to be a separate country, they voted no, 55 to 45. But the 3 major parties in the UK, on the eve of the election, very probably a little bit hastily, all promised the Scots they would have maximum devolution, something much more powerful than they now have. Steps like that will take the United Kingdom closer to the question, do we really need something in writing? Do we need at least an entrenched Bill of Rights, maybe a constitution? Because if devolution becomes something that begins to look a little bit like American federalism, that's what the Supreme Court was all about in the 19th century. It was about American federalism. Still is in many respects. So I think there'll be, my British friends are not going to hear this, but I think they better study some of the teachings of American government as they move through the next several weeks. Some of the mistakes we've made as well as some of the things we've done right. But thank you so much. Y'all have been just so great.